My name is Bo Frith, and I'm an attorney at Frith and Ellerman. I'm here to talk to you today a little bit about what is written discovery. It's one of those terms that you'll hear after the lawsuit is filed. So what typically happens is the lawsuit is filed, what's called the complaint, and we'll file that with the court, and then it'll be served on the defendants or defendants along with the lawsuit itself, that complaint, the written document. Defendants then have a certain number of days to respond to the complaint. And then typically what happens is they issue what's called written discovery along with their answer, their response. Written discovery is the process through which information is exchanged in a case, both from plaintiff to defendant and then from defendant to the plaintiff. Initially, along with, at the beginning of the case, along with the answer, the written discovery takes the form of interrogatories and requests for production of documents. Interrogatories are essentially questions in written form, either from the defendant to the plaintiff or from the plaintiff to the defendant, concerning facts in the case. So, for example, some typical interrogatories that defendant would issue the plaintiff are, who is your primary care provider? Did you have a stay at a hospital at all as a result of the injuries you suffered? If so, what hospital? How long were you there? Do you see any other treating physicians? For the past 10 years, what medications have you taken? Names of relatives, family members who may have knowledge of the facts or incidents that occurred as a result of this lawsuit. In turn, the plaintiff issues that information to the defendants. The second, along with interrogatories, is requests for production of documents. That is a written request for documents that may relate to information pertinent to the case. So your medical records, insurance information, that sort of thing. And that will be exchanged from the plaintiff to the defendant and vice versa. After this initial period of written discovery, there typically are depositions. Now that is not written discovery, but that's in-person discovery. That's where there are questions under oath, typically in person, or can sometimes be over Zoom electronically, where plaintiff's counsel or defense counsel will ask questions of the plaintiff, the defendants, fact witnesses, or expert witnesses. And that's in-person discovery, not written discovery. Typically after the deposition period, there may be additional written discovery as it relates to those depositions that will be exchanged. And throughout this time, both in responses to interrogatories and requests for production, we will work with you and meet with you to discuss your answers, your responses, and any pertinent documents you have that may respond to defendants' requests. Later on, towards the end of the case, there are occasionally what's called requests for admissions. Those are written requests under oath to admit or deny the information contained therein. That typically doesn't occur until later on in the case, towards your closer in time in terms of the trial, but that's something to be aware of. In short, written discovery is not something to be concerned about. It happens in every case. It's the way in which attorneys learn about the facts of the case, but it's something that occurs in just about every case and something to be aware of, although not something to be alarmed by. If you have any further questions, feel free to let us know. And I hope that this may shine some light in terms of what it means to conduct written discovery in a civil lawsuit. Thank you.